Bom dia, senhoras e senhores, todos
Good morning,
presentes.
ladies and gentlemen, and everyone else who's present. Since we have the quorum, we would like to declare open the 8th commission destined to subsidize the substitute minute for instructing the appraisal of bills number 50501 from 2019, 21 from 2020, and 872 from 2021, whose goal is to establish principles, rules, guidelines, and foundations to regulate the development and the application of artificial intelligence in Brazil. The present meeting destined to an international seminar, and we'll start panel number 4, data protection and regulation of artificial intelligence. I'd like to start saying that I'm glad to be the head of this panel with Gabriela Zanfir Fortuna, Dr. Robin Rederill. It is a pleasure to share this. We also have Dr. Laura Shelter following us remotely. Each guest will have 20 minutes to do this exposition. I would like to thank in advance for your presence in order to facilitate our interpreters' work speaking slower. And I would like to invite Dr. Laura Shelter to invite our first panelist. I'd like to thank you, Professor Miriam. It's a pleasure to share this table with you and with our illustrious guests. Well, I would like to introduce Dr. Gabriela Zanfir Fortuna, who's the Vice President of the Global University of Privacy Forum, where she leads the development of works on the field of privacy. Before moving to USA, she worked for the European Data Protection Supervisor in Brussels as part of the team who followed up and advised the legislators. She has a PhD on law school and a master's degree by the same university. Gabriela, it's a pleasure and an honor having you here. Please, now you have the floor.
Thank you very much, ladies and gentlemen. It's just an honor to be able to address you today on the topic of data protection frameworks and AI regulation. If I may share my screen for the presentation. I do not have the ability to share my screen. Thank you.
Gabriela, deve funcionar agora.
So I will talk today about how data protection law generally tackles automated decision-making and algorithmic decision-making, as well as at least some forms of artificial intelligence when it actually encompasses processing of personal data. In brief, I will make 4 points. The first one is that data protection law was developed as a general field in the 1960s and 1970s in Western Europe and the United States to tackle harmful consequences of automated personal data systems. The second point is that I would like to look at how current data protection law is relevant for automated decision-making and algorithmic decision-making. And we will look briefly at the GDPR, the General Data Protection Regulation in the European Union, and also at the LGPD, which is the General Data Protection Law that Brazil has adopted in recent years. Thirdly, we will look at a couple of examples of cases that have been decided under the General Data Protection Regulation and that are looking specifically on automated decision-making. And finally, for the fourth point, we will look ahead and we will look at how the proposals in the EU for the AI Act and the very recent and significant legislative proposal in the United States are adding protections or are creating a fundamental baseline type of protection specifically for AI, and how that protection will work together with data protection law to ensure that the rights of individuals are protected in this age of algorithms. So let me briefly start with the first point and talk about the foundations of data protection law, and look back to 1973 at a very influential report that was adopted in the United States called the Records, Computers, and the Rights of Citizens report. This is the report that conceptualized the fair information practice principles, which have been tremendously influential afterwards in the field of data protection law, and which we can find in the OECD guidelines for privacy adopted in the 80s. We can find in following data protection laws in the European Union, including now in the GDPR, and we can also find in the LGPD. Back then, when this commission was assembled by the Department of Health, Education, and Welfare of the United States, and when it started to think about how the protections could be put in place for individuals in the face of large automated databases and in the face of computers that were just starting to be developed, what was quoted as a growing concern was that automated personal data systems present a serious potential for harmful consequences, including infringement of basic liberties. So you see, the idea that personal data systems would be automated at a large scale was actually what drew the specialists to think about specific protections and come up with the fair information practice principles, which are now foundational elements of data protection law. Even if we look back in Europe at the same period of time, we can find in the French Data Protection Act of 1978 a prohibition of automated decision-making and a right to know that individuals had with regard to what was happening with their data if they were subject to an automated decision-making, as well as a right to challenge that automated decision-making. So this French Data Protection Act, which was adopted in 1978, specifically prohibited solely automated decision-making, so decisions based solely on automated processing in the context of judicial, administrative, or private decisions involving assessment of human behavior that would profile or define the personality of the individual. The same law granted individuals a right to know and a right to challenge the information, and also a right to obtain the reasoning and challenge the reasoning behind such automated decision, which is similar to knowing information about the logic involved in an algorithm that makes a decision that's impactful about an individual. So this is how we are left with some foundational principles that stay at the basis of laws such as the GDPR. In recital 4 of the GDPR, we have this statement which says that the processing of personal data should be designed to serve mankind. What this means, it means that the goal of data protection law is to ensure that information relating to individuals is collected and used, including by automated means and algorithms, in such a way that all their other fundamental rights are protected. So we have to process personal data, even when it actually builds AI systems, and even when it's used at large scale to automate decisions about individuals in such a manner that it is fair towards individuals and that it protects further their freedom of speech, the right to private life and privacy, the right to life, the right to security, the right to non-discrimination, freedom of assembly, and so on. But how is data protection law relevant in this day and age and in the age of automated decision-making? So what are those specific provisions that make this law to be addressing such complex technology like even AI? So we're going to look a bit at the GDPR and then immediately afterwards at some of the similar provisions that we encounter in the LGPD. First of all, data protection law well, specifically the GDPR in this case, has a broad definition of personal data. So the data that is covered by the regulation, which usually means any information related to an identified or identifiable individual. Now, any information covers a lot of types of information. Then it also has a broad definition of processing, which means that any operation or set of operations performed on personal data, like collection, structuring, combination, making data available, is covered by these rules. So this broad material scope of data protection law brings, in fact, training of models for machine learning, algorithmic decision-making, any form of automated decision-making that rely on personal data, even in mixed data sets where we also have non-personal data, under the scope of the GDPR, so therefore triggering the application of all of its rules. These rules are many in detail. Some of the most relevant ones for this particular scenarios would be the principles of fairness, the principle of accountability, the principle of transparency, giving transparency to individuals about this type of complex processing taking place. It also has an obligation on data protection impact assessment, which requires organizations that engage in complex processing operations to assess the impact that their processing activities have on the rights of individuals. And the provisions on the DPIA in the GDPR specifically refers to an assessment of the risks of that processing to the rights and freedoms of individuals. And then we also have a dedicated article in the GDPR on automated decision-making, Article 22, which provides for a right of persons not to be subject to solely automated decision-making that produces a legal or significant effects on individuals. And this article has been interpreted as a prohibition to engage in this type of solely automated decision-making by the European Data Protection Board. What else does Article 22 require? Well, it requires that if the decision-making is solely automated, so it's only done by an automated process, and if it has an impactful consequence on the individual, which has some legal implications, or which is similarly impactful, even if the implications are not legal, then only specific lawful basis for processing applied. That it can only be done if we have the specific consent of the individual, if we have the necessity to enter a contract, or if there is a legal obligation that allows this automated decision-making. When this happens and the exception is allowed on the basis of these three legal grounds, however, further measures must be put in place and suitable measures must be implemented to safeguard the data subject's rights and freedoms and legitimate interests. And these safeguards include as an obligation the right of the individual to obtain human intervention on the part of the controller, the right of the individual to express his or her point of view, and the right to challenge the decision, to be able to contest the decision. Now, the LGPD has similar rules. However, they are a bit different, even if they're similar, and we can find some differences there. It also has a broad definition of personal data processing, which means that it would cover complex processing of data, such as automated decision-making. It also has principles of transparency. It has a principle of responsibility and accountability similar to the GDPR. While it does not have a principle of fairness, it does have a principle of non-discrimination, which provides that it should be impossible to processing personal data for discriminatory, unlawful, or abusive purposes. It also has an overarching principle of good faith that is mentioned as a rule that covers all of the other principles mentioned in Article 6. It has an obligation to conduct, actually, it has a provision for data protection impact assessments, but it is more limited than what we're seeing in the GDPR because it should only happen at the request of the National Data Protection Authority of Brazil. And it also does not have a specific reference to fundamental rights and freedoms. There is also a specific dedicated provision to automated decision-making in Article 20. However, it does not encompass a prohibition for solely automated decision-making. Instead, it provides that individuals have a right to request a review of a solely automated decision that impacts their interests. They also have the right to request information on the criteria and procedures used for automated decision-making, but with due regard to business and industrial interests. So this might actually limit the right to obtain information about what goes into an automated decision-making. And then if information is refused, and only then, the National Data Protection Authority has the possibility to conduct an audit to verify discriminatory aspects in the automated processing. So you see, it is a bit trimmed down from what we are seeing in the GDPR. However, it does address automated decision-making. Now, all of these rules that we have discussed, are they meaningful in protecting the persons in the age of algorithms fed by personal data? They seem to be. Of course, there will be also some gaps in protection, but we have been recently conducting significant research on more than 70 cases in courts and by data protection authorities under the GDPR in Europe, given that data protection laws have a bit of a longer history there. So therefore, cases were quicker to appear in courts and in front of DPAs involving this type of complex processing. And we have found that very specific cases that involve algorithmic decision-making or facial recognition have actually been covered by provisions of the GDPR, such as a system that was based on facial recognition technologies and that was deployed in schools to monitor access on the school grounds and to control attendance of students. It was declared unlawful in France, for example. Also, instances like online proctoring in universities and automated grading of students, automated screening of job applications, algorithmic management of platform workers, distribution of social benefits and tax fraud detection, automated credit scoring, content moderation decisions that were made by social media networks. All of those were covered by the GDPR, and they were, the rules of the GDPR were applied by courts and data protection authorities in Europe, usually in an effective way to protect the rights of individuals. I will give you a very specific example of one of the most recent cases involving an emotion recognition AI system that was deployed by a bank in Hungary. It was deployed after it has been acquired from a service provider and used to analyze voice recordings of customers calling the bank. The AI system promised that it will detect the emotions and that it will measure the emotions of the customer calling in order to prioritize for callbacks, in order to prioritize a list for the bank to call their clients back, those clients that were considered to be most upset and impatient. Now, the Data Protection Authority of Hungary found multiple breaches of the GDPR. The principles of lawfulness, of transparency, of purpose limitation, the notice obligations, the right to object, the accountability obligations of the bank, and also the data protection by design and by default. And they issued a fine of 650,000 euros in February of this year. But the fine was issued for the bank as the controller. You see, the provider, the one that actually created this emotion recognition system, did not suffer any consequence. And this might be one of the limitations of the current regime under data protection law. Now, as promised, I would like to look ahead and look at what is happening now in the EU with the AI Act, and also bring to your attention some very recent developments from the United States, where last Friday, a bipartisan bill was published, the American Data Privacy and Protection Act, which is a comprehensive federal privacy bill that has some chances to be adopted according to the media. Now, in the EU, I will not go into the details because you have listened yesterday very detailed explanations of what the AI Act is doing. It's important here just to mention that the AI Act proposal is without prejudice to the GDPR, and it complements the GDPR. So they are supposed to work together. It just strengthens the protections, right? With provisions such as ex ante conformity assessments for high-risk AI systems that actually complement, and they're not similar and do not replace data protection impact assessments. Of course, we have the list of prohibited AI systems, and we have some other interesting provisions, such as monitoring of bias, which is allowed on the basis of processing sensitive data in accordance with the GDPR. So data related to health, race, religion, and which is mandated for high-risk AI systems. Well, in the United States, in this bipartisan bill that has chances to perhaps pass, or as I mentioned, this is how the media is portraying it, being that it comes from both parties. We have some very specific provisions that are looking at algorithms. And for example, there is a requirement for the large data holders, so the very big organizations that have a lot of data, to they have an obligation to conduct algorithmic impact assessments in order to mitigate potential harms to an individual. And we will look immediately at what that means. The same bill also provides for an obligation of all covered entities, all of the organizations that are covered by this bill, regardless of their size, to conduct something called an algorithm design evaluation, including any training data that goes into algorithms to reduce the risk of potential harms. So what are the harms that this bill specifically wants these assessments to take into account? Well, they need to be harms related to children, related to advertising for housing, education, employment, healthcare, insurance, credit opportunities, or they need to tackle disparate impacts on the basis of race, color, religion, national origin, gender, sexual orientation, and disability status. So as you see, this type of very specific targeted provisions on algorithms and their impact, even when they have personal data feeding them, are actually here to complement general data protection laws in order to provide significant protections to individuals. And I will stop here, and apologies for having gone 1 minute or so above my allotted time. Thank you.
Muito obrigada, doutora Gabriela Zanfir Fortuna, por essa
Thank you
apresentação.
very much, Dr. Gabriela Zanfir Fortuna, for your interesting presentation. I took notes of several things you've mentioned, especially your mention to GDPR and the personal data protection that should serve mankind. Very interesting, the references, the comparative references between GDPR and the LGPD, as well as the mention to the evolution of the legislative debate in USA and Europe as well. So thank you for your valuable contribution. Hereby, I would like to register the presence in our Senate chamber, Dr. Bruno Bione, who is beside me, and for all the professors, Felipe Mendon, Clara, Iglesias Keller, all of you, I would like to thank you for your presence. So I'd like to move on, introducing now your second panelist, Dr. Alessandro Mantelero from the Polytechnic University of Turin. Alessandro Mantelero is a professor on private law, private rights in the Polytechnic University in Turin, and he's part of the Society of the Mediterranean and law. He has been advisor for many artificial intelligence laws in Europe, in the United Nations for the European Commission and the European Agency for Fundamental Rights. His most recent book is titled Beyond Data, Allegations on Impacts of Human Rights by IA, was being published this year by Springer publisher. Professor Mantelero, you have the floor. Thank you.
Thank you very much for this kind introduction. It's a great pleasure and an honor to be here with you. And I share my screen for this brief presentation in which I would like to focus mainly on AI and AI regulation from the standpoint of the risk management. Because the risk management and the risk impact assessment is the key element, we can say, of several initiatives, several proposals that we have around the world, more specifically some in Europe, like the initiative from the Council of Europe and the initiative from the European Union. But this, of course, is the core, because we are concerned about the potential impact that AI may have on society. So I think that focusing on impact assessment in AI, the first aspect that we should consider from a regulatory perspective is that when we talk about risk, we can adopt two different approaches. The first approach is the risk-benefit approach. The second approach is the rights-based approach. And they are quite different also in terms of regulation. The risk-benefit approach, it means that you compare the benefits and the negative outcome of some technology like AI, regardless the nature of the benefits or of the negative outcome. So what it means that the efficiency of a system, the economic benefits are at the same level of fundamental rights and human rights. You can decide that some solution is more effective for smart cities, for instance, so create a better management of the traffic of the city, although it impacts on some fundamental rights like freedom of movement or freedom of association, etc. The benefit in terms of economic or efficiency can prevail over the other interest, because all the interests are the same level. And this was a quite debated topic. I remember I was in the CAI, the ad hoc committee on artificial intelligence Council of Europe. There was quite debated this topic between the different delegations. The second approach is the approach that is more familiar in the context of data protection, that is the rights-based approach. The rights-based approach, it means that it's true that there are different interests, but some interests, due to the fact that are human rights or fundamental rights, they have a better protection, a higher protection. And a clear example was provided in Europe, for instance, by the Google Spain case, in which was clear that the mere economic interest cannot prevail over the privacy, over the protection of personal data. So this is a sort of hierarchy between the interests. It doesn't mean that you cannot make business. It doesn't mean that there is not any protection of economic interests, but this should be done without affecting fundamental rights and freedom. So this is the first approach that should be considered. And in the right-based approach, of course, the focus is on human rights, like in the proposal issued by the Council of Europe and the European Union. And also in the proposal mentioned by Gabriella in US, we have an emphasis, I can say, on safety and discrimination that, of course, are part of the human rights approach. Another important point, if you adopt a risk-based approach, is that this leads you to an ex-ante approach, a prior assessment, you can say. That is the same assessment, by the way, that we have in data protection impact assessment or in private impact assessment. But again, this is an important point of debate, because there is a distinction between risk assessment and impact assessment. Risk assessment means that you assess the risk before it happened. Impact assessment, you assess the risk when the impact already exists. But if you adopt a quite human rights conservative, we can say, approach, so focusing on rights and their protection, necessarily you want to design an AI that is human rights oriented, that is human rights driven, In this sense, you necessarily adopt an ex-ante approach, like in the proposal issued by the European Commission, in which you have to assess the potential risk before putting AI on the market, before putting an AI device in the market. So if this is the approach, the distinction between risk assessment and impact assessment is no longer relevant, because if the assessment is before, necessarily you don't know the impact, but you want to prevent the impact. So for this reason, this is an important point that we have to take into account when we draft the text, for instance. In this approach, based on a prior assessment, risk assessment and impact assessment at the end are the same. And a second point that I want to highlight is that all the approaches that we have seen both in Europe and US with the recent American Data Privacy and Protection Act and bill that was proposed include some restriction, we can say. So compared to some experience, for instance, in data protection, the idea is that, yes, we have to consider AI, but only some aspects. For instance, there are threshold limitations in the Artificial Intelligence Act proposed in EU, where European Union focuses on high risk. It means that if there is a high risk application, there are some obligations, some also requirements in terms of impact assessment. If there are no high risk application, the obligations are quite low in terms of impact. And why? Of course, because this benefits the industrial policy. We have to be very concrete. There is a trade-off between regulating and boosting AI industry. So European Union adopt this approach that, by the way, is different from the approach suggested by the Council of Europe that adopt a broader idea, common also to data protection, in which we have to assess all the potential risk. A second point that we have in European Union Act proposal is a top-down approach. So it means that the high risk is classified by the Commission, is classified by the legislator. So there is a list of high risk application. The idea to use a list is not common, for instance, in data protection. We have not a list of data protection cases or uses that have a higher impact. The list, again, is in line with the industrial policy issue, because industry can say, I am in the list or not in the list. So it's easy in terms of compliance, but have some critical aspect, flexibility. Who will update the list? The proposal say the Commission. Yes, but this opened the discussion about when the list will be adopted, also the power of the Commission, etc. Second point, the interpretation of this list. If you create categories, you open a discussion about the interpretation of these categories. Some industry will define their application as not included in that categories by interpretation. So this is quite critical aspect. A second restriction that we see, for instance, in the recent proposal in US is the limitation due to the general limitation of the scope of the law. For instance, in the American Data Privacy and Protection Act, the focus is on large data holder. Of course, this is again a sort of size criteria that limit the application of AI provision only to the big player. And this is also a tension that we have in other countries. Big player, so the dimension of the player, or big risk, high risk, the dimension of the risk, are two, of course, criteria to be adopted. But we have not to underestimate the fact that we have many startups, many small players that invest in very innovative and potentially high impact application. And we have not to underestimate the fact that many small impact at the aggregate level can create a huge impact. So this quantitative approach has some tricky aspect to be considered. If we look at the potential model that we can use in order to assess the impact of AI on data protection, on human rights and fundamental rights, I think that the first things that we have to consider that the human rights impact assessment for AI cannot be a sort of expanded data protection impact assessment. Data protection and human rights are different. Data protection covers some issues. Human rights, each human rights have a jurisprudence, have a case law behind, have a theoretical background. This is clearly evident in Europe, for instance, in several initiatives, several models proposed by data protection authority, supervisory authority. There are references to the impact on fundamental rights, as mentioned by Gabriella, because it's required by Article 35 of the GDPR. But what is the problem? Usually is blank area in which is asked, there is any other impact on fundamental rights? But human rights, fundamental rights cannot be addressed in such a general way. We should consider the specificity of each kind of rights and considering the background in terms of its theoretical background and its jurisprudence. So an instrument more specific, more tailored, like the human rights impact assessment is of course better than expanding the data protection in order to include everything. The second important point is that the human rights impact assessment that we know, the traditional human rights impact assessment is quite different from the human rights impact assessment that we will like to see in AI. Because as far as we know, usually the human rights impact assessment is a tool that is used right now when there are big companies that start some initiatives in some specific area, like oil company in Africa, and have an impact on society, have an impact on the local territory. And so there is a request to assess this impact and to design some policy in order to better the situation. So this is an ex post analysis, not an ex ante like the one that we want to put in practice, first aspect. The second aspect is that this kind of approach are very focused on the context, while in AI we have applications that are used worldwide and not specific for only one context. And another element that we should to consider is that as far the impact assessment is very important to consider the different aspects that in traditional human rights impact assessment, for instance, the availability of houses, the impact on labor, may have not the same relevance in the context of AI. Finally, the crucial point is that human rights impact assessment usually is a policy tool. It's a support to guide the companies to better their performance with regard to the safeguard of fundamental rights or human rights. Here it's quite different because in artificial intelligence regulation, we want to introduce human rights impact assessment in order to check if there is an high or not an high risk, the level of risk, and there is a relation between the level of risk and the obligation. This means that you need some thresholds first, and second, that is not mere policy indication, but is a legal requirement. So being over or under the threshold make a difference in terms of obligations and in terms of sanction in some cases, depend by the law. So this is a different kind of impact assessment. For this reason, the experience, for instance, of the GDPR, in which we have a general assessment and a specific, more formal impact assessment for the high risk categories, could be also an interesting example because cover not only high risk, but for high risk, adopt a different kind of strategy. Then, of course, there are some issues in terms of transparency of assessment, because it's very important to be transparent about the assessment, also to create trust in the user of AI with some limitation, for instance, the protection of intellectual property. And it's very important to have a circular approach. So the assessment mainly in the context of AI is not a one-shot assessment, but you have to monitor how the system evolves and if there are new issues. A key point that is not defined in the whole debate on AI regulation is how to create standards. There are some voices in this sense in Europe, but standards like in data protection works well when you have some technology elements that are more or less always the same. So for security, they can work well. But for human rights impact assessment, each situation, each case is context-based, and there is not a standard that can be used for every situation. We can have models, but not standards. It's quite different. The second point is that, as I mentioned, we need some quantification, some evaluation of this risk for accountability, for transparency. And to quantify, we should use two parameters that are typical in risk assessment, likelihood and severity. I've seen several proposals, but it's very important to currently frame these variables, because likelihood is not only the probability of an adverse consequence, but should also
Parece que houve uma falha na transmissão. Vamos aguardar alguns momentos para ver se o professor Alessandro retorna, por gentileza.
in this system, we have to combine this variable, but not using a mathematical approach like multiplication, etc. But we have to rely on the expert that can combine the different impact and assess the risk, maybe also with the participation of stakeholders and right holders. An important aspect that we should also keep in mind is that there is not only one figure for the impact of an AI application on human rights, because each human right can be differently impacted by the same application. One application may impact on data protection, on freedom of expression, on physical integrity, but with different kind of impact, higher or lower, according to the different kind of impacted rights. So there is not a unified level of risk, but we have to consider the risk for each kind of impact. Then, of course, we can also conclude that an application is a high-risk application every time that only one human have a trade-off between the fact that the application have an high impact on privacy but has a low impact on physical integrity. So we can combine the two levels. So in terms of the future AI regulation, what element we can have to put in the regulation? First, it's very important to define the nature. I mentioned right-based or risk-benefit approach. So the nature of the risk and the scope. Only high risk, all the risk. Second point, identify clearly the parameters of the assessment in the law, because it's something that should be the same for all the assessment. Third, it's important to take into account the role of the high manufacturers, but also the user, not the final user, the citizen in the street. But for instance, you have a big company that provides an AI system to a municipality. Both the company and the municipality are engaged in shaping the way in which AI is used. And so the role is important to be defined with regard to the obligation in terms of assessing the potential risk. Fourth, transparency, participation, and accountability. Are treated about the assessment, because also you can better understand the risk of the impact on society of some application. Accountability, of course, if we talk about risk, we have to be accountable for the risk. The last point, I think that we don't need to put in the law a model of assessment. I think that best practices, guideline, all the soft law instrument can provide a variety of solution, a variety of methodology, contextualized, customized for each specific situation. And this is the experience of
Professora Laura, você gostaria de apresentar a próxima convidada?
Professor Alessandro Mantelero?
Yes.
Okay, so have you finished your speech already? Okay, thank you very much. Bom, então, muitíssimo obrigado. Agradecemos pela palestra do professor Alessandro Mantelero. Eu tive um pequeno problema aqui da internet, mas acho que está resolvido. Então, gostaríamos agora de apresentar a doutora Ftc Act. Ela é advogada no campo de telecomunicações, consultora de privacidade e proteção de dados e sócia sênior de um escritório de advocacia com sede em Accra, no Ghana. Ela também é fundadora e diretora executiva do Africa Digital Rights Hub, membro do UN Global Post-Privacy Advisory Group e membro não residente do Center for Global Development. Anteriormente, Ftc trabalhou para o governo de Gana no desenvolvimento de várias legislações importantes para o setor de TIC, incluindo a Lei de Proteção de Dados de 2012, Lei de Comunicações Eletrônicas de 2008 e Lei de Transações Eletrônicas de 2012. Ela também foi a primeira diretora executiva da Comissão de Proteção de Dados de Gana. Ftc possui um LLM em Direito da Tecnologia da Informação e Telecomunicações pela Universidade de Strathclyde, Glasgow, Escócia, e um bacharelado em Direito e Ciências Políticas pela Universidade de Gana. Por favor, doutora Ftc, a senhora tem a palavra. É uma honra tê-la aqui conosco e muito obrigada pela sua presença.
Thank you, Laura, for that. And thank you to inviting me to join this discussion. I would like to start on the premise that data protection legislative frameworks provide, and as Gabriela also noted earlier, provide some level of protection or regulation towards AI. But it does not necessarily address all the complications that we are looking at with AI currently. And on that basis, I'd like to start off by saying that generally, legislative frameworks are put in place more or less to regulate appropriate behaviors and protections to ensure that at least we can all live in a safe environment. And on that level, we are actually seeing the extent to which AI can affect and impact various aspects of our lives, and not just issues relating to data protection and privacy, but also issues relating to the environment, to climate, to discrimination, issues relating to the expression of one's freedoms, issues relating to economics and other rights. And this is to say that whereas data protection laws are relevant when it comes to looking at one aspect of fundamental rights, which is the right to privacy, we can see that there are also several other rights that are affected by the development, deployment, and use of these technologies. And so any attempt to develop an appropriate framework to address the deployment, and I'd like to stress on that, the research, the deployment, and the development, and the use of AI must look at the entire AI cycle and then understand what are the mischiefs, what are the problems, what are the challenges that we are trying to address. It is only in that framework that we will be able to come up with a framework that ideally helps us resolve a lot of the issues. Another key thing that I would like to emphasize on is the fact that when it comes to protections, we need to look at it from the perspective of principles, core principles that help address us. When it comes to developing laws that actually help with enabling technologies work in an environment or in a way that we envisage I am not sure, are you hearing me properly? Because I seem to be having some connection challenges. Okay, thank you. So what I was saying is that when it comes to technologies and development of laws that are appropriate, you would see, looking at data protection frameworks and other frameworks around technologies, that the laws position usually are always behind schedule. And that is why we typically go out looking for principles. We look at core principles. What these principles are seeking to do is to lay general foundations on which we then build, you know, the deployment and use and implementation of these legislations around. And so data protection, to a large extent, as Gabrielle said, provides this level of, you know, framework when it comes to addressing issues that relate to personal data. However, when we move away from there, we will see that there may be gaps around environment, there may be gaps around other ethical considerations that must be looked at. There may be gaps around, you know, other economics rights. There may be gaps around discrimination, to which we need to, you know, build frameworks that can enable it to address. What then we are faced with when we are thinking about AI regulations is that we're going to be faced with the same things that we see in the telecom space, with multiplicity of possible regulators, you know, and different entities working on different aspects of the area of technologies or the areas that it affects particular human rights on. We're looking at duplicity of different expertise. So finding people with various expertise on various subjects line coming together to create a framework that suits you know, the technology, or that suits AI technology. And that is just to say that when we are looking at developments of AI frameworks, we should be mindful that we are going to have to bring the engineers to the table. We should be mindful that we're going to have to bring the privacy experts to the table. We're going to have to bring the human rights experts to the table. And then we're going to have to bring the AI experts to the table in order to be able to carve a framework that will be able to address whatever challenge we are trying to meet at any point in time. And in order to be able to do that efficiently, we need to really understand the entire ecosystem within our jurisdiction. So if you're looking at, you know, you need to have an understanding of what is AI, for instance. If you're looking at Brazil, what is AI in Brazil? What does that mean? To what extent is this industry going to impact our economy, and which aspects of it? Are we part of the research part of AI? Are we part of the deployment part of AI? Are we part of the development, or are we solely users? And I believe that in each of the aspects or characteristics within the life cycle that I have mentioned, there are legislative interventions or frameworks that must be built to address that. If you're looking, for instance, at the area of research and development of AI, you want to think around what kind of data sets are we looking at? Because some of these data sets may span a much broader scope than personal data. In which case, if you have a data protection law, even though it will be able to address, you know, the personal data aspect of the data protection laws, it may not necessarily help you address the other aspects of data. Let's say public data, for instance, that is collected. Let's talk about data that is going to be used as for training modules that are not necessarily personal data. How do we intend to build on that? I know that Alessandro mentioned slightly issues around intellectual property. That is also an aspect. In order to make AI thrive, we have to make data available. What kind of frameworks are we thinking about building in order to make this data available? Because without data, there will not be AI. And so that data may not necessarily be personal data. It may be data that may have intellectual property rights associated with it. What are the frameworks that we are building? How do we allow sharing of such data under these circumstances? So while AI data protection regulations and frameworks, I think, provide a significant guidance, then I don't want to belabor that point because I think Gabriel did a good job in throwing out a lot more light on how data protection guides that. My conclusion is that that only looks at the incorporation in the development and use of personal data. But then outside of that scope, there is a whole lot more other kinds of data that is being collected by AI systems, which are not personal data. And whatever frameworks that we are building should look at mimicking that. In the end, what we may end up seeing in this space, we're going to see multiplicity of regulators coming into the space. Let's say, for instance, we are developing an AI module to support the financing industry or a bank in particular. The data involved may be personal data, there may be other financial sector data that is coming to play. Clearly, I can see maybe the central bank or the regulator of the financial systems coming to play when it comes to use of data that is not necessarily personal. I am also seeing how we can data protection regulations and laws or frameworks apply. I can also see how a regulator generally of technology, a lot of our countries right now have IT regulators that regulate IT. I can see how they're coming into play. And so any framework that we are building must look at all these other aspects and factors, including the regulators that are likely to be affected by these, and then build a framework that will enhance collaboration and coordination of all these complex aspects of making AI work. That will be all for now. Hear me? Hello?
Okay. Olá, nós ouvimos. We can hear you.
So I think that would be all. I'll leave the rest to maybe a question time, and then I can respond to specific questions that came out of that.
Muito obrigada, senhora Ftc Act.
Thank you very much, Mrs. Ftc Act. Very interesting, your presentation, especially with regard that the artificial intelligence affects the right to privacy, but also other fundamental rights. It's also very relevant, reminding, looking at the whole AI life cycle when we think about conceiving a regulatory framework to tackle this technology. So I would like to go to our last panel today, Mrs. Robin Wetterill from USA. She is a lawyer from the Division of Identity Protection, Consumer Protection in USA, and she works with investigations, agreements, and litigations on privacy, as well as regulatory and political processes. Mrs. Robin, thank you very much for accepting our invitation. Feel free to have the floor.
Thanks so much for that introduction. And I want to start by thanking you as well for inviting me to participate in this morning's panel. It's an honor to be here. And thank you so much also to my fellow panelists. I've truly enjoyed listening to these very interesting presentations and have learned a lot from them. So just to briefly repeat and introduce myself. I'm an attorney with the United States Federal Trade Commission's Division of Privacy and Identity Protection. And just for clarity, the views I'll be expressing today are my own and not those of the Federal Trade Commission or of any individual commissioner. As I'm sure everyone is aware, the United States currently lacks an omnibus privacy law at the federal level. Some of my fellow panelists this morning have pointed to potential future legislation or regulation of AI in the US. My focus today, however, is going to be how existing US laws enforced by agencies like the United States Federal Trade Commission relate to AI and similar technologies. So I'll begin by providing some background about the United States Federal Trade Commission, or the FTC. The FTC is a federal civil law enforcement agency that was created by an act of US Congress in 1914. And Congress has tasked the FTC with pursuing a two-part mandate encompassing both competition or antitrust and consumer protection. My work falls under the consumer protection umbrella, so that aspect of the Commission's work will be my focus today. And though the FTC's primary tool in fulfilling its twin mandates is law enforcement, the agency's efforts to conduct and promote research, policy initiatives, and consumer and business education and outreach are also vital to our work. Of course, it's an understatement to say that the US economy has changed significantly since 1914, when our agency was founded. And in particular, the last several decades have seen major advancements in technology, including advancements leading to the development of cutting-edge technologies like artificial intelligence that are the focus of this conference. Nevertheless, many of our longstanding legal authorities and other tools remain highly relevant to our efforts to protect consumers from the potential harms associated with these technologies. So before I discuss some of our legal tools in more detail, I want to briefly cover some of the FTC's relevant research and business guidance from the past decade. And this work is a crucial driver of our enforcement actions and of our policy priorities, and offers key insights into both the potential harms to consumers and ways that businesses can avoid or mitigate some of those harms as they are considering adopting some of these technologies. So back in 2011, the FTC held a public workshop not dissimilar to this conference called Face Facts, a forum on facial recognition technology. The workshop gave the Commission and its staff an opportunity to hear from experts in the field of facial recognition, then a relatively nascent field. And we also received more than 80 public comments responding to the comment of the workshop. And the outcome of that process was a staff report published in 2012 that laid out recommendations for companies using facial recognition technology. Those recommendations included that the companies design their services with consumer privacy in mind, develop reasonable security protections for the information they collect, and sound methods for determining when to keep information and when to dispose of it, and consider the sensitivity of information when developing and using facial recognition products and services. So for example, the report recommended that digital signs using facial recognition technologies should not be set up in places where children congregate, so that they would be likely to collect the personal information of children. Though there have been significant advances in facial recognition technology since 2012, many of the recommendations of that report remain relevant today. More recently, in 2016, the FTC published a report titled Big Data, a Tool for Inclusion or Exclusion. This report, which was also based on a public workshop, addressed the rise of so-called big data and big data analytics and the potential of these developments to lead to disparate outcomes based on consumers' race, gender, or other personal characteristics. For instance, the report highlighted that reliance on correlations in data had the potential to reinforce existing disparities, create new justifications for discrimination, result in price discrimination, expose sensitive information about consumers, and weaken the effectiveness of consumer choice by allowing businesses to simply infer personal information that consumers wish to keep private. The report went on to offer guidance for companies seeking to avoid or reduce consumer harm in connection with their use of big data analytics. Now, the report doesn't use the terms AI or algorithmic decision-making. Many of its recommendations are also relevant to AI because many AI technologies are essentially analytical systems that operate very quickly using very large data sets. So specifically, The report urged companies using big data analytics to ensure that their underlying data sets were representative of the populations that would encounter or interact with those systems, to think carefully about how the data sets had been generated and identify and account for biases in the available data or algorithms that were created using that data, to consider the potential risks to consumers if the algorithms arrive at inaccurate results, and understand how and why their algorithms arrive at particular results, and how the algorithm's results may be dependent on certain conditions, and therefore vulnerable to changes in those conditions. We also recommended that companies use meaningful human oversight of algorithms used for critical decision-making to mitigate risks to consumers of inaccurate or biased results, and center considerations of fairness or equity in making decisions related to how and even whether to use this technology. And the report specifically noted that in some cases, fairness and ethical considerations may advise against the use of big data for certain purposes. An FTC staff blog published just last year in 2021, entitled Aiming for Truth, Fairness, and Equity in Your Company's Use of AI, drew on these reports and other resources and work to offer guidance to businesses seeking to adopt AI tools. For instance, the post urged businesses to carefully consider whether their models are trained on complete and representative data sets, and to limit where and how they use the models accordingly. The post also emphasizes the importance of testing algorithms both before and after deployment, and urges companies to be transparent with consumers and outside observers about what technology they're using and how, so that those observers can help ensure that the technology is being used fairly. Finally, the blog post warns against making deceptive, exaggerated claims about the abilities of AI or using AI in ways that are likely to harm consumers. Now I'm going to turn to an overview of how some of the FTC's longstanding legal authorities, including our original statute dating back to 1914, continue to be relevant to the development, marketing, and use of AI technologies. And I'll begin with the Federal Trade Commission Act. So in relevant part, the FTC Act declares that unfair or deceptive acts or practices in or affecting commerce are unlawful. But what does it mean for an act or practice to be unfair or deceptive? Well, a company engages in a deceptive act or practice if it makes a material representation or omission that is likely to mislead consumers acting reasonably under the circumstances. And a claim could be misleading either if it is false or if it's unsubstantiated, meaning that the person or entity making the claim does not have sufficient evidence to support the claim at the time the claim is made. So in the AI context, just as in the rest of the economy, marketing claims about an algorithm's accuracy, efficacy, or lack of bias could be deceptive and therefore unlawful if they're false or unsubstantiated. The FTC has taken action against companies for deceptive conduct related to AI. And one example is the FTC's 2015 settlement with the operators of a mobile application called Mole Detective. Marketing for the Mole Detective app allegedly claimed that the application could analyze photographs of skin moles uploaded by users and could determine whether the moles were cancerous. And the FTC alleged that these representations were deceptive and therefore unlawful. Another example of the FTC's deception authority at work is a recent settlement that the agency reached in 2021 with a company called Everalbum. So Everalbum operated a consumer-facing mobile application that allowed users to upload and organize their personal photographs. The FTC alleged that Everalbum had made representations to users that their photographs would not be analyzed using facial recognition unless the users affirmatively acted to turn on a facial recognition feature. In fact, for users in most geographical locations, the facial recognition feature was turned on by default and could not be turned off. And furthermore, Everalbum allegedly used consumers' images uploaded to the app to train facial recognition models, including models that they then repackaged and sold to other businesses. Therefore, the FTC alleged that Everalbum's representations about its use of facial recognition were deceptive. Now, what about the unfairness prong of our FTC Act authority? An act or practice is unfair if it is likely to cause substantial injury to consumers that is not outweighed by countervailing benefits to consumers or competition and is not reasonably avoidable by the consumer. So for instance, as laid out in more detail in the 2021 blog post that I just mentioned, if a business uses an AI tool in a way that is likely to harm consumers more than it benefits them, that business may be engaging in an unfair practice that violates the Ftc Act. Other laws enforced by the Ftc are relevant as well, and an important example is the Fair Credit Reporting Act, which governs the creation, sale, and use of consumer background reports for purposes such as determining consumers' eligibility for credit, housing, or employment. Credit reporting agencies that create these reports have used algorithms for decades to assemble and evaluate information about consumers, including to generate credit scores. The FCRA imposes requirements on these companies, including that they must adopt procedures to ensure the maximum possible accuracy of consumer reports. In 2018, for example, the FTC reached a settlement with a credit reporting agency called RealPage, alleging that it had failed to use reasonable procedures to ensure the maximum possible accuracy of its consumer reports as required by the FCRA. And specifically, RealPage's matching algorithm allegedly used very broad criteria to match individual consumers with criminal records, and then reported those criminal records as belonging to that consumer in reports that were furnished to landlords for use in tenant screening. The FTC further alleged that RealPage had no procedures for testing or assessing the accuracy of the algorithm's results, and that as a result of these cumulative failures, RealPage had violated the FCRA. Pursuant to a settlement with the FTC, the company was required to pay a civil penalty of $3 million. Anti-discrimination laws also continue to apply in the AI context. The FTC enforces a statute called the Equal Credit Opportunity Act, which prohibits discrimination in the availability and terms of credit. The Equal Credit Opportunity Act prohibits both intentional discrimination and what is called disparate impact discrimination, that is, practices that have the effect of disproportionately harming members of a protected class. For example, in 2010, the FTC settled an Equal Credit Opportunity Act claim against a company called Golden Empire Mortgage. The FTC alleged that Golden Empire had a policy of allowing broad employee discretion in determining what fees should be charged to customers seeking mortgage financing. As a result of this practice, the FTC alleged, the company charged significantly higher fees to Hispanic borrowers. Golden Empire had also allegedly failed to monitor whether its prices were discriminatory or were having a disparate impact on protected classes. Now, imagine that rather than allow broad employee discretion, a creditor relies on an algorithm to evaluate how much consumers should be charged for credit or whether their applications should be denied. If the use of this algorithm results in worse terms or more rejections for a protected class of consumers, then that procedure may run afoul of the Equal Credit Opportunity Act, just like the employee discretion policy in Golden Empire Mortgage. In addition to the question of liability, of course, there's also the question of how to remedy harms flowing from AI. And one approach that the FTC has recently taken in several cases is to seek a remedy that has been referred to as algorithmic disgorgement. For example, in the Everalbum matter that I mentioned previously, pursuant to its settlement with the FTC, the company was required to delete not only all the data that it had obtained through allegedly deceptive means, but also any work product that it had created or derived in whole or in part using that data, including any models or algorithms. So the goal of this remedy is to ensure that companies that violate the law cannot continue to derive benefits or advantages from their past unlawful conduct. And the FTC has also obtained this remedy against companies including Cambridge Analytica and most recently, a company called Curbo, the operator of a weight loss application for children. And in that case, the law violation in question was a violation of the Children's Online Privacy Protection Act. So one reason that case is significant is that it points to general privacy laws and restrictions and their relevance to the AI context. Because really, anytime you're thinking about data collection, at this point, we should also be thinking about the implications of collecting and amassing consumers' data for training or for use in connection with AI. So before I conclude, I want to briefly mention that while I can only speak to the activities of the FTC, we are far from alone among US government agencies using and seeking to use our existing authorities to meet the new challenges and questions raised by the growing adoption of AI. And for instance, the Consumer Financial Protection Bureau, which regulates consumer financial products, has announced efforts to combat the harms of algorithmic bias in areas including fair lending and real estate appraisal. Another US agency, the Equal Employment Opportunity Commission, which combats employment discrimination, has likewise launched an initiative to ensure that AI and other emerging tools used in hiring comply with federal civil rights laws. Of course, those are just a couple of examples of efforts across the US government. In conclusion, I want to again thank you so much for inviting me to speak today on this important topic, to our excellent moderators, and to all in attendance for your time and attention. Thanks.
Muitíssimo obrigada, doutora Robin Weatherhill. A gente gostaria de agradecer imensamente a sua participação, assim também como a participação dos demais, e aproveitar o tempinho que ainda nos resta para pedir para que cada um dos senhores e senhoras façam um comentário final e também possam comentar algo que é muito, uma reflexão que a gente tem visto tanto no Brasil quanto fora, que é sobre a relação entre os princípios da proteção de dados, os clássicos princípios da proteção de dados, da necessidade e especialmente da finalidade, e dessa relação com as novas aplicações de inteligência artificial. Há uma contradição entre esses princípios e as aplicações de inteligência artificial ou não? É possível se pensar nessa aplicação desses princípios à inteligência artificial ou, ao final, precisaríamos de uma releitura desses princípios clássicos da proteção de dados? Então, essa seria uma pergunta ao final que a gente gostaria que os senhores, se puderem, endereçassem juntamente com as conclusões e uma fala final de cada um. Eu gostaria de sugerir, se a gente pudesse seguir a ordem das falas, talvez a doutora Gabriela Zanfir poderia falar primeiro e, em seguida, a gente seguiria também a ordem dos palestrantes. Gabriela, could you comment on that?
Yeah, I'm sorry, I did not hear the, I mean, I heard it in Portuguese and I did understand you said my name and a couple of words, yes. But I did not.
Okay. Miriam, would you like to explain, maybe?
Of course. So I'll switch to English. Thank you all panelists for your wonderful speeches. And I'd like to invite each of you to provide some final words and, if possible, to address a question that has been many times discussed here in Brazil and elsewhere that concerns the relationship between these principles and rights and tools that we have developed over so many years to deal with personal data protection in view of these new technologies, and in particular the principle of purpose limitation, of minimization, for instance. Are these principles incompatible with AI, or should we think of reconsidering them or using them as they are? So if you could please provide some final comments on this point in 2 to 3 minutes, I would appreciate it very much. And we will follow the same sequence of presentations, so beginning by Dr. Gabriela and then moving forward in the same order. Thank you very much.
Thank you very much for this wonderful question. And my short answer is that I believe they are compatible with the new technologies. But at the same time, we need to look at the challenges posed by very complex technologies like AI. And we need to see how we can complement this protection that the existing principles provide. And if this means a technical approach like the EU is suggesting with the conformity assessments prior to launching AI systems on the market, or if this means specific algorithmic impact assessments that look at discrimination and avoiding discrimination, this could be some of the solutions out there. I believe they can work together. Thank you.
Professor Alessandro, would you like to provide some thoughts on this issue?
Yeah, thank you. I'm a bit more skeptical, and I share with you in the chat the guidelines of the Council of Europe on AI and data protection. I think that, for instance, if you consider minimization, a minimization principle, as we know, cannot be managed well in the context of AI. but we need new solution. For instance, synthetic data is an interesting option. If we look at purpose specification, the purpose changes and changes continuously in some cases. And so we have to consider other options like dynamic consent, broad consent. So I think that this principle, as we know in data protection, can still be here and also for the future, but should be partially reconsidered also from a technical approach. And then I think that we cannot rely only on data protection. As I mentioned in the presentation, data protection is only a small part of the entire picture, but there are other issues that cannot be fully addressed if we consider only data protection as the main reference for our work. Thank you.
Thank you very much, Professor Alessandra. Mrs. Tecchi, would you also like to add some comments?
Yes, I think that in order to be able to effectively deal with that, we have to really look at each context and then ask ourselves again, what are we trying to, what is the mischief that we're trying to cure with minimization and with the purpose limitation? As long as those continue to be relevant in data protection, I believe that it has some role in AI. Perhaps the question we should be asking ourselves is whether it would apply to all contexts of AI. And I think that is no. But in the areas of processing of personal data with AI, I think that it is something that we may have to really have a critical assessment of. After all, data protection laws allow for some level of what do you call it, anonymization and pseudo-anonymization that makes available some level of data, you know, which I believe could be used by AI. But in all of these, for me, if there is a risk to the human being, and that risk is significant compared to the benefit, I think that I will err on the side of protecting the human being and then pushing for, you know, for the machines to have their field day.
Miriam, we can't hear you.
Can you hear me now? Okay, I think
Yes.
now it's working. So thank you very much, Ms. Akwete, for your comments. I'd like to ask Ms. Webbill also to provide some final remarks.
Sure, and thanks for the opportunity to respond to this excellent question. I agree with Tecchi and Gabriela that I think data minimization and other kind of core privacy principles not only are not inconsistent with our with the need for AI regulation, but in fact go hand in hand with the need for regulation in this space. And one reason I say that is because you know, I think that the existence of AI and the common use of AI actually make some of those privacy rights more urgent because they transform the nature of the data. And so kinds of data that we might have previously considered less sensitive now are quite sensitive because of ways that AI technology can be used, for example, to you know, use accumulated images of a face to create convincing kind of imposter videos of a person. And that has broad social implications that affect individual consumers and that affect, you know, have political implications as well. And so, you know, we really need to be developing rules of the road in these areas, you know, side by side, hand in hand, and ensuring, as Tecchi said, that we don't kind of, you know, abandon some of these core rights or the core, you know, needs of individuals in the face of the potential for major technological advancements.
Excelente. Professora Laura, a senhora gostaria de fazer algum comentário final antes de partirmos para o encerramento?
Bom,
Professor Laura, do you have any comments before we wrap this up? Professor Miriam, I would like to thank you for this great panel where we had a very broad approach on the relationship between data protection law, how it is greatly interesting and it supports issues on artificial intelligence and helps mitigating the risks of algorithms and at the same time on the limitations of such data protection tools. So just a huge thanks to Dr. Gabriela Zafir Fortuna, Professor Alessandro Mantelero, Professor Ftc Act, and Robin Weatherill. Thank you very much. Thank you, Professor Laura. And so we'll wrap up this panel, and I would like to reinforce huge thanks to our panelists who brought priceless contributions to our commission in Brazil. I'd like to thank also the interpreters and the Senate committee who's been supporting us. Also, I'd like to thank everyone who sent questions by e-Cidadania portal. Gustavo Santos from Amazonas, Pedro Henrique from Bahia, Epaminondas de Sá from São Paulo, Aragrande from Minas Gerais, Jefferson Christian from Ceará, Erica Liza from Bahia, Carlos Mendes from Santa Catarina, among many, many others. And I believe these issues had been somehow very interesting along the expositions. And if we didn't consider them in our panel, we'll consider them as jurists. I'd like to request our panelists that make their to send their presentations via email so that they can be made available in our portal of the Federal Senate. Hereby, I would like now to wrap up the commission of the Federal Senate, and I would like to inform that we will suspend the seminar for 5 minutes so we can make a few translation tests, and we'll return soon. And I would like to wish everyone a great day.
May I do a quick systems check and make sure I can be heard and seen?
In inglês?
Hi, Pam.
To test the audio and the translation, I'm speaking in English. So
Okay, thank you, Clara. Merci beaucoup.
Yeah. Yes, I can hear you very well, Pam.
Thank you very much. I do have some slides. Will it be a problem to screen share for a portion of my chat?
Okay. Bruno, Pam has some slides. Can you hear me?
Yes, Laura.
Okay.
Pam,
Okay.
they will provide access to share your slide and your screen.
Yes, I'm very happy to do that. I can also send you a copy of the slides. I have a fresh copy. I keep editing all the way up until a moment ago, but I can also just share the slide from the screen, and that would be fine either way.
Ok. Ela pode testar o compartilhamento da tela dela? Ela está pedindo isso. É a Pan Dixon. Ela está como co-anfitriã agora? Pen, I think now it's working.
Do you want me to test it?
Yeah, go ahead.
Okay, it should be fairly easy. Famous last words. Alors. Ça marche? Is that working?
Yes, perfectly. We can see your screen. Thank you.
Okay, very good. Thank you. I'm going to stop the share. Thank you.
We are just going to do some additional tests with regards to the translation, and then we are going to start in a few minutes. Vamos lá. Bom dia a todos e todas.
Good morning, everybody. I would like to reopen the session of the Jurist Commission on Artificial Intelligence of the Federal Senate. We will move on with panel 5. It's being carried out in these 2 days. The panel 5 will tackle regulatory techniques and the risk-based approach. Our guests are Mr. Grath from the European Commission, Mrs. Penn Dixon from the Worldwide Privacy Forum, and Courtney Lank from the Industrial Council of the Industry of Technology, of Information Technology. Here, I would like to register the presence of my fellow colleagues, the Commission peers, and now I would like to move on immediately to Professor Laura Sherton Mendes, who will introduce our first panelist. Thank you very much, Bruno. It's a pleasure to share the moderation of this panel with you. I would like to thank you once more, the illustrious presence of our three panelists. And I would like to invite Mr. Eichengrath, who's from Chief Department Officer on the Department of Public Policy for Fundamental Rights of the European Commission. His work is focused on the application of fundamental rights and had been working with recent proposals such as AI Act, as well as other non-legislative works to tackle the hate speech on the internet. I had worked with public policies on the governance of artificial intelligence, as well as research. Ike Grath, thank you very much for your presence. You have the floor.
Thank you very much for this conversation. I understand that yesterday my Commission colleague already presented the proposal for an AI regulation in general. So I will focus today on specific aspects that the organizers signaled would be useful to discuss. And of course, I understand this panel is about regulatory techniques and the risk-based approach. So that will be my main focus. I will then also in the end briefly speak about human rights impact assessments and spend a very short moment also on related work that the Commission is preparing on AI and civil liability. And I think I will repeat one key point a few times in the next 20 minutes, and that is that it's really useful in our context to differentiate between an AI system as an entity and the practice that is its use. So there's the system and there's the practice. And we do, of course, acknowledge that both can be considered as a socio-technical system as a whole. And so the system and the practices are not disconnected, but they are different parts of what we regulate. And the AI proposal, the AI Act, is one piece of this puzzle. And another important piece, or several other important pieces, are the laws that we already have. And for this new proposal, the AI Act, the choice to propose a horizontal regulation, so the full harmonization of the rules in all EU member states, that would cover in one horizontal law different AI technologies that would be used in very different situations, is the first point I want to discuss. And of course, there is the observation that different AI technologies, not all of them need to be based on machine learning. There can also be expert systems, for example, or approaches that are sometimes debated, like automated statistics. All of these technologies can lead to a certain opacity and complexity of the resulting system. And that comes then also to challenges with predicting the outcomes produced with the system. And so this horizontal approach is chosen because certain of these characteristics that cause these challenges in different situations are technologically similar. And so to avoid chaotic requirements on similar systems across different sectors and situations, the Commission proposed to have this one horizontal approach that covers the different technologies and the different situations. And really important is, of course, and I heard Dr. Gabriela Sanfi-Fortuna say that this new proposal is without prejudice to the data protection rules that we have already. And the same is true for the proposed Digital Services Act, which might soon be agreed on, and labor rules or rules on consumer loans. So these are all relevant to the use of AI systems, and there's an interplay between them. the AI proposal is about the systems. Other instruments that I just mentioned govern behavior in certain contexts. They concern the practices. And we could say that the users of an AI system that are subject to the rules, for example, in the area of consumer loans, or if they have a labor platform, they are subject to fundamental rights obligations. And the objective with the AI proposal is to help these users of the technology, the users of the system, assess the legality of the practice that they envisage. And then if there would be a problem, they could adapt or avoid the practice if this is necessary. So that about the horizontal part. Now about the risk-based approach that was also discussed already in the first panel this morning. It guided the overall conception of this proposal, and as you saw, led to different obligations for different risk categories. So first of all, in shaping the scope based on a risk-based approach, it's important to highlight that it is technologically, the scope is not limited to machine learning only, but it covers all AI systems that would, in our view, correspond to the problem definition. I mentioned before technological challenges like opacity or complexity can hinder my own assessment if what I want to deploy is actually legal, because I might have difficulties finding out if I use it in a discriminatory way. I don't want to spend too much time on this because I understand it has been discussed a lot in these today and yesterday. So I need to check my notes just a second. Yes. So these characteristics that I mentioned about opacity and complexity and so forth, they of course can arise where machine learning is used, but they can also arise where other systems are used. So the Commission chose a quite broad definition to make it future-proof, so it can evolve over time. And another reason is, I mentioned this just in the beginning, we have on the one hand the system as such, and then on the other hand the consideration that it's part of a broader socio-technical system. And it can be conceivable that there are some elements of a technological system that rely on machine learning, others rely on other technologies, but together they form a whole. So that is why there is this broad first scope. And then there is a second trigger for the majority of the obligations in this proposal. The situation where it is used is really key. So the risk that comes from the specific purpose of the system then triggers the main body of obligations. There are also a few situations where the use is outright prohibited, and there are a few situations where transparency is required. But I want to focus really on the high-risk systems, which then would trigger document obligations to test the system, to document it, to maintain the documentation, and also to give access to that documentation to relevant authorities supervising the respect of fundamental rights. So in a way, this approach is both risk-based and rights-based, because to protect fundamental rights, of course, they continue to apply in full. We heard this several times today, and they continue to be binding and be enforceable. And the idea is not only to keep it that way, but to help with the respect, with the implementation, and also with the enforcement of these rights. And in helping, we propose this new regulation, which follows the risk-based approach. So here, the idea is where we need, because of the opacity, of the complexity of a system, an extra effort to keep the rights that we already have useful, we impose extra duties. And these duties must be proportionate, and therefore we use this risk-based approach. And there was an impact assessment accompanying the proposal where the Commission and also contractors did a lot of work to identify in which situations do we know already is the use of AI systems a risk to fundamental rights or to safety. And this is then how the situations that would lead to a high-risk categorizations were identified, and they are contained in the annexes 2 and 3 of the proposal. So this is the next important point for the risk-based approach. It's the EU legislator that defines what is risky and therefore who is in scope. Professor Mantelero mentioned that there would be a risk of circumvention if the regulated entities would get to make a risk assessment themselves, and they could then define their own practice as not risky and therefore claim that they would not be in scope. So this is not our idea. We proposed very clear situations where somebody is in the scope and then has to comply with all of the rules in this AI Act. I will not go in much depth on the substantial rules. I just mentioned the keywords already: testing, documentation, providing access to authorities. I want to add a keyword that I did not mention before, and that is that the provider of a system has to give important information to the user of the system about its characteristics, but about also how it was created to allow the user to use the system responsibly and in accordance with their obligations. So this information that they should transmit includes also the capacities where the system works well and its limitations, where it would maybe not be reliable and therefore should not be used without further caveats. And this package of obligations, which there are also more on accuracy, on robustness, and so on, has to be then checked for conformity. And there is a conformity assessment. There are different approaches in the law. Sometimes it is controlled by a third party. Sometimes it is the provider themselves who conducts this assessment, but it could always be checked by an authority. And that's the important point I want to add also here. The conformity assessment speaks about the conformity with this new AI Act. And this new AI Act is a tool to help with the compliance with safety rules and fundamental rights rules. But conformity with the AI Act does not mean compliance with fundamental rights ex ante from the outset, just from looking at the system. Because to know if a system is used in compliance with fundamental rights, one really needs to look at its concrete use in a concrete context. So it's important to remember that compliance here does not automatically mean that the use of a given system would be lawful. And this now brings me to the second point that I was asked to address, which is the question of human rights impact assessment. So this would be something where the user, the deployer of the system, is best placed to do this. However, most of the rules, not all, but most of the rules in the AI proposal concern the provider of the system. It's true that the users have a lot of visibility of how they use the tool. They have therefore visibility on the risks and also control over how they meet the risks. So we have currently in the EU a discussion. There are civil society organizations and also members of the European Parliament who suggest to have a binding fundamental rights impact assessment on the user. And I want to explain why this was not part of the initial proposal of the European Commission. And this is exactly because this piece of the puzzle is focused on the provider, and they might lack the information that is necessary to do this fully fledged human rights impact assessment. Nevertheless, in the Commission proposal, the users have certain obligations. For example, they must take the instructions from the provider into account, and they must also ensure that they use input data where this is applicable in a suitable way. And of course, and that's a very, and somehow obvious point, but it's important, the users have to respect all their existing legal obligations. And in some cases, to be able to do that, they will have to assess what they are going to do, and they will have to assess the risk of falling short of their fundamental rights obligations. So that's implicit. But we, of course, also have an explicit regime which was discussed just before, from the data protection acquis. So in many cases where personal data is processed by means of AI systems, I even would say in all, a data protection impact assessment is already required from the user under the current data protection rules. And this assessment was also discussed just before. It covers not only data protection privacy, but all rights and freedoms of the data subject. Now, in principle, the Commission considers that where no personal data is processed and an impact assessment would be added, and we follow the discussion closely, of course, any additional assessment should really be complementary and avoid duplications of what is already required. And in principle, we consider that further rules that would govern the practice, the use of an AI system, should be defined not in this horizontal piece of legislation that focuses on the system, but in the rules that govern the relevant context, the practices there. And examples would be employment or money lending, which are both high-risk areas in the AI proposal. So systems in these areas are in scope for a number of purposes. And here we can illustrate how it would work together. For example, in a recent legislative proposal of a directive on improving the conditions of people working through online platforms, the Commission did propose an obligation on the labor platform to regularly monitor and evaluate the impact that their automated management decisions would have on the working conditions of the people working through the platform. So this proposal, once adopted, would very much benefit from the AI Act once adopted, because then all the testing and documentation about the system that the platform uses would already be there. It would have to exist in a certain way, quite a detailed way, and there would have to be the possibility to access it under certain conditions. And this, of course, would help then the platform also to make their assessment on the effects on working conditions. And one last point that I want to mention in this context is that in all cases that fall in scope of this AI regulation, with the authorities in charge of fundamental rights can, within their mandate, access any documentation about the AI system. So one thing is, of course, the impact assessment of the expected impact that the use of the tool would have. Another thing would be, and that's what we have here, information on what the system does, what it is optimized for, how it was built, in what way it works. And in some cases, it could include the logs of the system. So logging of how it is used, where the user maintains these logs. So there is a lot of information that could be interpreted by an authority or by a court. And that would give quite a clear picture. It's different from an assessment that might have to be published, but it's also an interesting element to consider that exists in this proposal. I see I have about 3 minutes left, and that should be just perfect, because the last point I want to mention is the initiative on liability rules in view of AI use that complement the policy I described up until here. And this is currently under preparation. There will be a directive that would provide targeted alleviations of the burden of proof. It would include rebuttable presumptions on liability, and provisions on access to information for the victim, for a person that would be harmed through the use of an AI system. Because the problem description here was, how do I find out who to turn to when I am facing this opaque system? I don't know if it was defective. I don't know if it was who is responsible for the defect, but the provider of the system or the user of the system would normally be in a better position to access that information. So there would be targeted changes to the burden of proof and to the information regime. And this new legislation would again benefit from what has to be recorded and documented pursuant to the AI regulation. So it is really, again, other pieces of the puzzle that function together. And I can say that in terms of timing, this initiative on civil liability for AI is being prepared in parallel with the review of the EU legislation on product liability. And both initiatives should be presented in the third quarter of this year, so quite soon. And with that, I want to thank you, and I stay here for the discussion a bit later on, if I understand correctly.
Nós que agradecemos.
We would like to thank you, Mr. Akegraph. We had the opportunity of we've been hearing about the European Commission talking about the responsibilities and what's being done so far on this proposal. It's been extremely rich and fruitful. So now I would like to invite our next panelist, Mr. Spen Dixon from the Worldwide Privacy Forum. Spen Dixon is the founder and director of this institution, the Worldwide Privacy Forum, who is a respected group of research of public interest. She's also an author and researcher. She has written several influential studies on civilian identity, artificial intelligence, on healthcare, and complex data ecosystem and their respective governance. Dixon has also worked extensively on privacy in several jurisdictions such as USA, India, and Africa, Asia, European Union. And currently, she is the co-president of the working group in judicial regimen on statistics of the United Nations, as well as a focal point by part of the civil society and intersectorial efforts in a recent working group created in the Organization for the Cooperation and Socioeconomic Development, OECD. She has also introduced papers on governance, data ecosystems for the National Academy of Science and also in the Royal Academy of Science. Now I would like to invite Spen Dixon for the floor, and I would like to thank you for availability to speak in front of this commission.
Well, thank you very much for your kind invitation to be here today. As you mentioned, I'm Pam Dixon, founder and executive director of the World Privacy Forum. My work has been about 30 years in really a combination of technical and policy work, looking at large, complex data ecosystems and both their technical and policy impacts. So that's really what I've worked on. In India, we spent a year researching one of the largest AI and machine learning systems in the entire world called the Aadhaar ecosystem. And our work on that was cited extensively in the India Supreme Court opinion, which is a landmark privacy decision in India on an identity and AI machine learning system. So we're very proud of our work. And I'm really delighted to be able to share some of the things we've learned from looking at both the technical and policy aspects of these ecosystems, not just in the global north, but also in the global south, and the lessons that we've learned. So let me go ahead and just start very briefly and discuss the AI and machine learning ecosystem. As we know, in 2019, we could have a conversation that would look very different than the one we can have today. Today, because of the acceleration of AI and machine learning systems that the pandemic created, we are looking at a different scenario. And we need to be very, very careful to understand that the world moved ahead about 10 years, maybe a little bit more. So whatever we were going to do, we need to think a little bit further ahead because of this acceleration. And I'm going to outline how that can happen in just a bit. One of the things that is very important to understand about what has happened since the pandemic is that we can no longer think about AI and machine learning as a national or even a regional ecosystem. We must be able to think of these ecosystems as global ecosystems now because of how they are working in reality. The reality is that that AI and machine learning systems, you know, when we think of providing regulation for these systems, we think of systems that are visible to us. But increasingly, we're moving into a world where these systems will not be visible to us. They will be much more like the plumbing in houses. You know it's there, you can turn the water faucets on, but it won't necessarily be that you see the pipes. And we're rapidly moving to that. When that happens, it requires a slightly different form of regulatory controls. So you've got to take a combinatorial or a combined approach to address all of the risks of the systems. And there are regulatory pathways to do this. And I wanted to mention, I'm going to be going through this in a bit more visual detail in my presentation, but I wanted to discuss the role of exemptions, or sometimes called derogations. Many meaningful AI and machine learning systems are exempted from the GDPR and from similar regulations that exist around the world. This is not unusual. So for example, the National Statistical Offices, or NSOs, have exemptions. The national security and law enforcement have exemptions. Public health systems, not private health systems, but public health systems. So for example, the systems that dealt with COVID-19, COVID-19. So these public health systems are generally exempted as well. So when systems are, when very meaningful systems are exempted, what on earth do we do to ensure that there is good rules of the road everywhere? And this is where different kinds of regulatory controls can come in, so that there can be controls, but flexibility within that. And then finally, I wanted to just preview that what I'm really going to be talking about today is what a mature systems approach looks like to both the policy and the technology. And this is from the inception of the system to the development of the system, to the uses of the system, to the consumer individual redress for problems in the system, and then of course to required improvements in the system through time. So I have some slides to share with you, and I will make these available to all of you. But let me go ahead and share my screen with you now. I hope that it is smooth. All right, let me try. Et voilà, je crois que I think I did it. All right. So basically, right now we are in a situation where most AI and machine learning regulation is very contentious. I believe we can make that cooperative with the right approach, and I would like to propose that to you. Let me check my time. Okay, I have just enough time for this. So I wanted to make a statement of the problem in relationship specifically to the question I was asked to address on this panel, which is that, you know, when we are talking about the entire life cycle of an AI or machine learning system, the entire throughput of the ecosystem does create or can potentially create very meaningful risk. The risk is a continuum. It's not all at the highest level. It's not all at the lowest level. And the shades of nuance in between these two extremes are profoundly complex, and they are so many. There are so many possible contexts and ways that these systems can create risk. But one thing we can say very certainly is that the the level of risk now is high enough that we need a regulatory process to address the risk specifically. And also, we need to really think about the landscape of regulatory policy and ensure that it is harmonized and not fractured, because what happens in one jurisdiction is going to meaningfully impact another, because the way AI systems work today is that they are not always developed from scratch. They are often borrowed, shared, repurposed, and you can end up having AI systems shared globally in just a matter of moments. So let me go ahead and commence. So first, this is just a simple global table of jurisdictions with comprehensive data privacy laws in one form or another. And the different colors represent just simply the different regions. So you can see them through the march of time, how chronologically different regions moved to adopt in waves data privacy legislation, and it is still ongoing. This was current as to last year. So this is the basic map, and you can see the developing world is moving very, very strongly to adopt either GDPR-like regulation or something very, very similar. These regulations provide a baseline for certain aspects of AI, but not all of them. It is not a complete system of regulation. So because of that, and because there are still jurisdictions that do not have comprehensive privacy regulation, and because even comprehensive privacy regulation does not address AI very, very well, we are left with a very fractured and non-systemic tool set for addressing the risks of AI. So right now, we really have, for AI, we have a lot of national AI strategies. We have a lot of principles for responsible use, which is great. We do have some limited legislative controls. We've done an analysis of what these controls look like. And most of the jurisdictions, particularly those that do not have GDPR, have very focused controls on specific use cases. One of the more popular is biometrics, such as face recognition systems, which use an AI technology called convolutional neural networks, a form of machine learning, a very complex form. And as these have been subject to moratoriums and bans, but this has been kind of the approach to deal with a high-risk system. This is not a sustainable way to approach high-risk systems, because historically, even if a system is worth having a moratorium, these tend to only last for some time. So we need a deeper way of addressing risk. So my proposal is to think about an adaptive and cooperative system where there's a whole of government approach where possible, where the stakeholders that have within government and also in the private sector, when they have a role in AI, such as national statistical organizations, data protection authorities, those who hold data, such as very large companies or platforms, data donors. This tends to be relevant to the health ecosystem. And then, of course, data users, which are very many. There are many, many contexts for this. And then, of course, it's very important to identify both horizontal and vertical integration opportunities within each jurisdiction and government. This can begin at the national level and filter down to the subnational and even the municipal level. So there is a very clear pathway for this, actually, and it is already in effect in almost every country in the world. And that is the various chemical safety provisions. These particular provisions have a lot of administrative and procedural controls that work beautifully for AI systems to reduce risk and to address risk. So we've done here a very, very deep dive on chemical safety regulations around the world. And we've extracted from these chemical safety regulations the key procedural and administrative controls that can be brought to an AI system. The models change in these systems, but the thing is that they're used globally, and the systems, each jurisdiction has developed its own system, but they are harmonized globally. There's a common vocabulary that is harmonized by both the United Nations and also the World Health Organization within the health context, but the UN within a broader context. And this provides a definitional baseline around the world on certain terms. This is very important, actually, so that when people are talking about chemical safety, everyone's talking about the same thing. When you say the word lead or mercury, everyone knows what that means. And the cutoffs for when something is dangerous or perceived of as dangerous, these are all very similar. They may not be identical, but they are harmonized in a similar way. So let me talk first about some very specific models and some of the procedural examples that come from them. One of the very important models comes from the European Union. There are two major chemical safety regulations in place. One is called REACH and one is called RoHS. And this is how I pronounce it. It may not be correct, but anyhow, RoHS and REACH both contain very, very important procedural and administrative controls. So for example, each of the systems have, before anything can go to the market, there must be an identification of the risks associated with that product. There must be a demonstration of compliance to mitigate those risks specifically. And there have to be use guidelines that are in place that ensures that those substances will not pose a health risk. Now, in the RoHS regulation, it has additional controls. There must be clearance prior to launch in the market, which is very important for AI. All the parties in the supply chain must provide documentation and keep it updated on an ongoing basis. And then there is mandatory compliance labeling. So all of these features, if we use, for example, a very simple example of the face recognition, could you imagine if face recognition products were labeled and treated in this way? It would provide much more transparency. It would provide a systemic regulatory approach. If we had this approach globally, jurisdictions could decide their policy, but these administrative and procedural safeguards as to the quality of the product would help profoundly. Now, RoHS has been enacted outside of the EU by Japan, Korea, and China. There are also at the state level in the US, there are several states which have also enacted RoHS. Now, in the United States, we have the Chemical Safety for the 21st Century Act. This was updated not so long ago. It was updated during the Obama administration. It requires pre-manufacture notification for new chemical substances. So for example, in the case of AI and machine learning, this would require notification for the reuse or use of any major system. This would be more for a government context. After a risk assessment, which is mandatory in the US system, where risks are found, it requires testing by all members of the food chain or the manufacturing chain. In the context of AI and machine learning, this would include those who are adding data to the system, those who are adding technologies to the system, and those who are deciding on end uses and monitoring end uses in the system. All of this needs to be considered before. And then, of course, there are requirements for certification and compliance and reporting and record keeping requirements. And then, of course, there are requirements for notification if there is risk that is found at any point in the continuum. In India, India is a really interesting case study here. They had their own chemical safety regulation, but they recently changed it and updated it substantially in order to join the UN's Global Harmonization Strategy, the GNA. And now India has joined that. And they modeled their regulations after a slightly different model, but they're still very strong. But the idea is that they will now have an inventory. They have moved themselves into a very good category by this update. And it is all the addition of all those rules I was talking about. And then in Africa, it's the same thing. You will see very frequent monitoring, testing, and adjudication of these kinds of procedural rules. And I had already mentioned the way of harmonizing these rules. I think something like this will happen for AI and machine learning systems. I don't think that there is very much a way around this because these systems are being used around the globe already. If you think, for example, of the World Health Organization, I co-chair a data governance committee there. And one of the tasks that we had during the pandemic was to figure out how on earth to harmonize all of the data flows coming in from the COVID situation. We had data flows coming in from healthcare providers, from governments, but also from private sector organizations. It was a very complex ecosystem. And I think we will see more of that, not less of that. But in general, I wanted to talk about the hallmarks of a mature cooperative regulatory system for AI. There are thousands of types of AI with more coming. You need an umbrella approach that can harmonize all of these elements under one set of overall tools that are available for procedural and administrative controls. This is at a very technical level of regulating the ecosystem itself. So you still need science-based and procedurally sound methods. You will need principles and responsible use, regulator-approved codes of conduct, that is under GDPR Section 40, comprehensive restricted use regulations when they are required. We need to look at uses in a very systemic way. There are some use cases which we will find unacceptable in our cultures, and we need to be able to address those in a very, very science-based, systematic way so that we can make sure that our decisions are sound. The bans and moratoriums that exist today would be much, much better researched and thought through, and they would require regular review. And in this way, you have a very, very regulated system. And I'm going to go ahead and stop my share. So that is the basic overview of how the actual regulatory process would work. Now, the context of this is that for jurisdictions that also have comprehensive privacy regulations, these systems would need to work together. But I think that they can. But AI ecosystems and machine learning ecosystems in and of themselves require a great deal of comprehensive regulation before they ever hit the market or go to the market, because we are very quickly moving to a time where we will not have a lot of transparency into these systems. During the pandemic, one of the things that happened, and I'm only a few minutes from my time, so I'll be very mindful of that. But during the pandemic, one of the things that happened is that there was a real focus on moving data ecosystems into real-time AI-enhanced data ecosystems. This is great for trying to recover from a pandemic. This is really great for public health infrastructure. And the majority of the world's jurisdictions are quickly adapting to these real-time and AI-enhanced ecosystems. But when this change is complete, and it is not complete yet, but when it is, we need to have governance in place that will minimize risk before the products are brought to market, because aftermarket will become much more difficult. We'll need to have a way of having a comprehensive system where all of these risks can be plugged into an existing system of procedural and administrative controls, such as compliance labeling, required impact assessments of a variety of kinds, and also required what's called surveillance, not surveillance in the way we usually use it, but surveillance in that when consumers have a complaint, they can make a complaint. When there is a system that is found to be violating human rights or violative in another way, then these systems can be corrected and there can be oversight and auditing of these systems. So these are these are not exciting controls, but these are very necessary controls and will really help over the long term to address these risks that we're facing and to address the technological change that is coming to us very quickly. Thank you very much for the opportunity to share with you these ideas. I stand ready, waiting to assist in any way and to share any information that would be helpful to you. Thank you again.
Doutora Pam Dixon, muitíssimo obrigada pela excelente participação, pela excelente contribuição, extremamente.
Thank you, Pam, for your excellent participation. It's an extremely vast topic and approach about many other regulations. It's been a very good panel for all of us. Now I would like to call our next speaker, Dr. Courtney Lang, with Senior on Public Policies and Technology of the Industrial Council of Technology and Information, ITI. In the ITI, Courtney leads the development of policies in institutional relationships, engaging with governments worldwide, and also
no segmento de telecomunicações e o estabelecimento de uma nova rede de segurança e infraestrutura crítica. Por favor, Courtney Lang, você tem a palavra e nós agradecemos muitíssimo a sua presença.
Great, thank you so much. I also have some slides to share, so I will attempt to do that now. No, I am disabled from screen sharing. I'm sorry. I forgot to ask about that at the beginning. So I can also just talk through my presentation.
Yes, you can now.
Yes, I can. Okay, perfect.
Yes.
Yeah. All righty. Here we go. So thank you again for having me here today. As mentioned, my name is Courtney Lang. I am Senior Director of Policy for Trust Data and Technology at the Information Technology Industry Council. For those of you that are unfamiliar with my organization, we represent 80 of the world's most innovative technology companies. We really represent a broad spectrum of technology companies, including those that manufacture IT hardware, software. We also have platforms and service providers in our membership. So we represent kind of the broad array of the technology industry. So I'm really happy to be here today to talk a little bit more about our perspective on regulatory techniques and specifically risk-based approaches to artificial intelligence. I think an important point to make at the outset is that we are a global association, and so our membership is based all over the world. We not only represent US companies, but also companies that are based in Europe and Asia Pacific and elsewhere. So we really come to this conversation with a global perspective of the environment around artificial intelligence, as well as the things that our businesses are seeing as new regulatory approaches are being considered and implemented. So I won't go through this in great depth, but I just wanted to provide some context similar to, I think, what Pam just discussed. There's many artificial intelligence policies that are being kind of thought through around the world. I've included some examples here of various largely guidelines as opposed to regulation that's being considered. And I'll talk through just a few of them a little bit later in my presentation, but I did particularly want to flag the US has a memo that's been out for some time now for federal agencies, the guidance for the regulation of AI applications, as well as our US National Institute of Standards and Technology is now also developing a voluntary AI risk management framework. And so I will mention a little bit more on those two items at the end and our perspectives on those. Also just wanted to flag a couple of frameworks in the Asia Pacific that might be useful for the Senate to look at as it's considering how it's going to move forward with its legislation. And then, of course, we are all aware of the European AI Act, and we had our panelist at the outset talk through that. So I will not spend a lot of time walking through that, but will instead just share a couple of perspectives from our membership on that as well. I'll spend the vast majority of my 20 minutes talking through our perspective on approaches to AI regulation. This actually comes from a set of policy recommendations that we developed in conjunction with our membership in March 2021. We published it publicly, and it's broader than just regulation, but there is a specific section focused on discrete recommendations for policymakers as they consider how to approach the regulation of AI technology. And so I'll walk through kind of the steps that we propose policymakers take, which I think might be useful as Brazil is thinking about how it would like to specifically structure the legislation. So first and foremost, we've encouraged policymakers to really evaluate existing laws and regulations to determine whether there are gaps or whether there is a need for additional laws. So as I think some of the other panelists have mentioned, it's important to kind of evaluate the use and impact of AI in specific applications and further evaluate whether existing rules might address concerns or not. So there are things, as we mentioned, data protection laws that already exist, which may address, for example, concerns around automated processing, things like that. There are also liability rules that may address discrete aspects of concerns related to liability. And so really ensuring that those rules are being assessed and then further understanding whether there is a need for additional legislation to address concerns is kind of the first step. In doing so, we also caution Brazil and others to be careful of avoiding kind of conflict of law, because that makes it very difficult for companies to figure out how they can comply. So we also, urge policymakers to consider further clarifying how existing laws also apply to AI as the technology continues to emerge, and also how AI can be used in compliance with existing laws. So that's kind of the first step in thinking through AI regulation, is really assessing whether it is needed, and if so, where. Another area that we've encouraged policymakers to consider in developing AI regulation is the use of international consensus-based standards. Of course, these sorts of standards are key in establishing consensus around various concepts, and they do really help to provide a common lexicon, not only for inside the government, but also across borders. They can help to then facilitate interoperability and alignment of approaches, which is going to be very important because, again, as some of the prior panelists mentioned, this is really a global ecosystem, right? It's not just happening in one country or another. And so to the extent that approaches can at least be aligned by leveraging common foundational concepts and themes, that will be really important. So there is ongoing work taking place, for example, in ISO IEC Subcommittee 42 on AI. They recently published several AI-related standards on governance, on trustworthiness, and they've also launched work to develop standards on data quality, explainability, transparency, AI taxonomy, and others. So we really think that kind of looking to these standards as a starting point would be helpful, because there may be practices in there that are going to be applicable moving forward, and there may be measures that can be incorporated into potential legislation, and that will, again, help to increase interoperability across borders. This is kind of the hallmark of our recommendation, and I think is something that we've seen in the EU AI Act, which we're of course supportive of, and that's the need to really take a risk-based, context-specific approach to AI regulation. And so, what we mean by that is essentially that risks need to be identified and mitigated in the context of the specific AI use, because this will help, right, policymakers to determine what use cases or applications are of particular concern, and will similarly help to avoid kind of prescriptive regulatory approaches across the board that may stifle innovation. So one of the things that we've encouraged policymakers to consider moving forward is to work with stakeholders to really consider how to characterize what constitutes a high-risk application of artificial intelligence, including by identifying the appropriate roles for AI developers and users in making those risk determinations. I know earlier in our presentations today, our colleague from the European Commission mentioned that it's up to the government to be making those determinations, but there may also be a role for stakeholders in helping to develop that criteria that actually goes into deciding what is a high-risk AI system. And so we've actually offered some amendments to the EU AI Act to, I think, further clarify some of the criteria that's contained therein for assessing what is a high-risk system. But that being said, I mean, our view is that an AI decision is a risk when a negative outcome could have a very significant impact on people, especially as it pertains to health, safety, freedom, discrimination, or human rights. With that being said, I think it's important to note that kind of a broad focus on sectors or designating, for example, an entire sector as being high risk may serve to actually lead to very broad categorizations, right? Health as a sector, not every single application of AI within that sector is necessarily high risk. Of course, there may be particular uses or applications that absolutely are high risk that could seriously serve to undermine safety or human rights, but not every single application within that sector is high risk. So again, being very specific and precise about what those use cases are will be incredibly important moving forward, because that will help to ensure that regulation is incredibly targeted at those use cases that are of the most concern and pose the greatest risk to humans. And that'll lead me to my final point on this, which is really differentiating between human-facing and non-human-facing systems and how risks might differ, because they may differ quite significantly based on whether a system is human-facing or not. A human-facing system, for example, may implicate privacy, but a system that is not human-facing and is simply, for example, processing weather data and then sending that data to another AI system to analyze it, it's not facing humans. It may not have the same privacy risk or any privacy risk associated with it at all. And so really differentiating between those two types of systems will be important, because the risks associated with systems that are facing humans versus those that aren't will differ. And then finally, with regard to approaching AI regulation, we encourage Brazil to undertake efforts to align around common parameters, including considering what the scope of AI is. In general, we've encouraged policymakers to coalesce around parameters as to what constitutes artificial intelligence to, again, advance globally consistent policy approaches. So we've encouraged in the comments that we've submitted to the committee that a definition of AI focus on two key themes. The first being a focus on software that actually learns, and then the second, again, focusing on AI in context. So really allowing the definition to focus on specific use cases. So we're very supportive of the definition that has been adopted and put forward by the OECD, which you can see on the screen. I will not read through the entire definition, but it really addresses the need to focus on learning systems while also being mindful of the specific context of the different parts of the AI development lifecycle. And so if the committee adopted a definition with a similarly granular view, that could support more detailed guidance around the specific risks and mitigations appropriate to the different stages of AI development. I think a final note around scoping in the context of regulation, I think it's important that scope is very carefully articulated, because that will kind of form the baseline for any additional regulation moving forward. And so we've encouraged, again, a focus on systems that learn, as opposed to kind of incorporating traditional software, general software that doesn't necessarily have the capability or the capacity to learn and evolve in that manner. So again, just ensure that the scope is sufficiently clear moving forward. I also wanted to hit a little bit on the role of transparency because I know that this is another area that policymakers globally are thinking of and are considering, how to utilize transparency as a potential risk management measure. And so just wanted to offer some high-level thoughts around that. I think first and foremost, it's important to note that transparency is not an end in itself. It's a means by which to enable accountability, empower users, and further build trust in a system. So again, it's a tool. It can be used as a potential risk mitigation measure, but it is not kind of the ultimate goal. So again, it can be used in conjunction with other tools to help to facilitate trust in the AI system, and in some cases can be used as a risk management measure. So we're actually in the process of working with our members to provide a more detailed set of guidance around how we believe transparency should be utilized in the context of AI regulation. But I will talk through a couple of high-level points here, recognizing I am already rapidly coming up on the end of my time here. But in the context of this specific legislation that the committee is thinking through, we really encourage folks to consider what the objective of transparency requirements are, because that will kind of facilitate an understanding of what the best way to achieve those objectives are. So what I mean by that is the objective, for example, to tell a consumer that they are interacting with an AI system. That might be one objective of a transparency requirement. Another objective might be to allow a regulator to assess the AI system for safety. Another objective might be to allow a user to understand or interpret the results of a AI system so that they have the appropriate information to kind of contest that decision. So there are different objectives related to transparency. And so figuring out which objective you're trying to meet will be helpful, and then ensuring that whatever kind of requirements are being imposed are the appropriate ones for that objective. With that in mind, it's important to also be very clear as to what is meant by transparency. I have often seen transparency and explainability be conflated in conversations, and they are not exactly the same thing. As I said, there are different types of transparency. There's kind of disclosure, information provision, but then there's also kind of this concept of explainability. And usually when we talk about explainability, we mean post hoc explainability, right? Or allowing somebody to understand how a decision was made after the fact. And post hoc explainability coupled with interpretation can help a user, for example, to understand how a decision was made. I will note with a caveat, though, that thus far, most explainable AI tools have been actually currently targeted more towards system engineers and developers as opposed to the average consumer. And so there are still limitations around explainability tools. We have also encouraged, once again, policymakers to take a risk-based approach. Again, there might be instances in which it absolutely makes sense to have a transparency requirement. If a system is high risk in particular, then it might make sense to apply transparency requirements to that, kind of as we're seeing in the EU AI Act, right? But perhaps low risk systems don't really require that same level of transparency. I also want to note that when discussing transparency in the context of this sort of legislation, should be very clear that we're referring to transparency of AI systems as opposed to algorithmic transparency more broadly, because that does serve to capture a broader swath of algorithms, right? Algorithms are one part of an AI system, but they're also parts of other things. So I think I will just quickly wrap up here, noting that I am almost at time. I had a slide on the EU AI Act proposal, which I believe we've already talked about, so I will not go into great depth here. As I mentioned earlier, we are generally supportive of the overarching approach that the EU AI Act seeks to take, particularly because it kind of applies more stringent conformity assessment requirements, et cetera, to high-risk use cases. That being said, we do have some outstanding concerns around several of the articles, and so have offered some amendments to hopefully help policymakers there improve them in a way that will help make the regulation more effective while simultaneously allowing for innovation. And again, I won't talk through all of these in great depth, but I did want to note, there are areas that we think could be further improved moving forward. And then finally, on the US approach, just to note that there is not currently horizontal legislation to govern the use of artificial intelligence in the US. There has been some legislation proposed in US Congress to focus on discrete aspects of AI. Most notably, as we've mentioned, we've seen some around algorithmic accountability and potentially in biometrics, but nothing as comprehensive as what we're seeing in the EU. We're really seeing more of a voluntary principles-based approach in the US right now. As I referenced earlier, we have the OMB guidance that kind of directs agencies to incorporate a series of principles into their thinking about how they might approach both regulatory and non-regulatory approaches to AI, and then also the NIST AI risk management framework, which sets forth essentially a mechanism by which organizations can identify, assess, and manage risks associated with different types of AI systems. And so that's still in process, but we think it's going to be a very helpful tool to not only help organizations and stakeholders understand kind of the broad ecosystem of AI and the stakeholders there, as well as provide specific kind of outcomes that they might want to achieve based on the specific functionalities that are laid out there. So I recognize that I believe I am just a few minutes past my time, so I will wrap up there, but I am really happy again to be here today and looking forward to continuing to work with Brazil as they develop their legislative approach. Thank you.
Thank you all for the enlightening contributions. I'm sure that all of them will drive our efforts at the Commission in order to find a proper and balanced regulation on AI. And I'd like to put a general question for all panelists. And I'd like also to invite to make your final remarks. Laura just also sent the writing question in the chat in order to facilitate the understanding of the question. One of the structural critiques made in general with regards to a risk-based approach from environmental law, but also through passing through that protection, arriving in the emerging regulations proposed on AI, is that they are too procedural. Particularly, the critics say that this approach grants a lot of discretionality or discretion to the regulators, and is too formalistic, lacking substantive measures or protections. So in this sense, how to find a proper balance in order to craft the regulation without being too prescriptive or being too vague and fall respectively into a command and control technique or a pure self-regulation.
Bruno, there is an echo just in order to... Tá tendo eco, viu, Bruno? Só para você saber.
Vou repetir em português ou em inglês? Bom, então eu vou tentar repetir em português.
All right, so I'm going to try to repeat in Portuguese. I would just like to say that the question has been sent here in the chat in order to make it easier for the panelists to understand. So basically, the question is that there's some structural criticism about the approach of the regulatory approach, that is something that comes from the environmental law and personal relationships, and in AI in general. So the criticism is that this kind of approach in technical regulatory it gives a lot of space for regulatory actors that are being too formalist, and some substantial measures are missing here. So in this context, how can we design a regulation that is more balanced and that is more balanced without being too prescriptive or vague, consequently being a commanding and control technique or just a regulation, really. I'd like to invite all of you to make your final remarks. You each have about 4 minutes tops.
And I understand from the chat that I have the floor. Is that right?
Yes.
Thank you.
Por favor, Eike.
Thank you very much. If I made some faces right now, it was because I had some audio issues. Please do not misunderstand this. So I have two reactions to this question. The first is that in the case of the AI proposal, I think it's fair to say that the risk-based approach would not lead to vagueness because the Commission in the proposal already did the job of examining the risks and then defining clearly a scope in which situations the use of which systems leads to the obligation to comply with the new rules. And then the new rules are very concrete on, let's say, accuracy, on robustness, on what has to be tested and documented. There are then, I didn't mention this in the initial presentation, even efforts to further concretize thanks to technical standards that the European standardization organizations work on. So the idea really is here that it is not too vague and that we help people that have to comply with very clear instructions. At the same time, of course, there is an obligation to have a risk management for the providers of the high-risk systems. And here the orientation comes from the concept of state-of-the-art. So this is a well-established concept in what we call the new legislative framework in product safety. So that was the second element of my reply. And this is also to support that I think in this case, with this proposal, we did avoid it being too vague or too formalistic. The procedures should be as clear as possible, and we are really working towards that, including with the standardization organizations. And we are optimistic that the co-legislators, the member states, and the parliament will keep it that way. I was also allowed to add my final remarks. I just want to make two. The first one is really to repeat the main message that the intention with the proposed AI Act is not to regulate any type of action that could be carried out with an AI system, but in using AI to help the implementation, the respect, and the enforcement of our existing laws. So in short, one really could say we create the basis for people to check how the system works, and thereby we enable accountability and ensure safety and the respect of fundamental rights. And the second remark, after that I will stop, is a reaction to what Courtney Lang raised about the distinction she made between transparency and explainability. So what counts as an explanation, or what kind of explanation would be required, is a very rich debate, also in view of different pieces of EU legislation. And in view of AI systems, an explanation is not necessarily always the most useful element. An assurance that it works reliably in the same way at all times might in some cases be more useful, or an assurance that the results would not lead to discrimination. So what we did in the proposal is we did not use the concept of explanations, but we require that the system be interpretable to the user of the system, and that they can then interpret also the outputs to use them correctly. And this is again paired with other situations where an explanation might be required. So that would be, let me use this example again, the new rules proposed on people working through platforms, where the labor platform would take certain significant decisions, like on scheduling shifts that impact how much I earn as a platform worker, or even the termination of my account. There, they are obliged to provide an explanation in writing within 1 or 2 weeks. So we have again the puzzle. The AI Act provides the basis for what is necessary. And then on the other hand, we require the explanation because we expect that the information is there. So that is again in view of the regulatory technique. And with that, I stop. Thank you very much.
Thank you so much. And just thank you again for this opportunity to discuss with you this very, very important issue. It's really one of the issues of our time. So just very quickly, checking the time. Okay. So just to recap, artificial intelligence and machine learning is moving into a real-time state. This introduces a lot of changes in how regulations can be effective. It makes it more difficult, much more difficult. And we need to understand that that is coming rapidly. Secondly, global harmonization will be quite necessary in these ecosystems for a lot of technical and policy reasons. We can have jurisdictions creating what they need for their context, as well as also having a baseline of a harmonized approach with, for example, baseline definitions, etc. But something to keep for all of us to keep in mind is that artificial intelligence and machine learning is moving very rapidly into becoming what is generally known as a general purpose technology. We have seen this happen with the internet. I remember in the earliest days of the internet, we used to say the World Wide Web. To get on the World Wide Web, you say HTTP. This is a URL. This was very early days of it. Now we just, the web, the internet, it's part of our common day. And AI technologies and machine learning technologies are very rapidly going to enter this place. And when that happens, the possibilities for regulation, meaningful regulation, really change. You've got to do a lot pre-market before they're ever out in the world. And this is why the approach of having systemic, comprehensive procedural and administrative controls is very important. We should not be differentiating between human-facing system and non-human-facing system. All AI systems should have quality control. We should be able to subject all of these systems to very simple but meaningful administrative and procedural guidelines and to have labeling. If we have a weather sensing network, it should be good. It should be a good and trustworthy weather sensing network. If we have an AI or machine learning system that is, for example, used for purposes of national security or law enforcement, in the creation of that system, we must have proper controls so that that system functions to proper parameters. These are starting points and very necessary starting points. We have to ensure that whatever products are out there in the market and become very much embedded in our lives as the internet has done, we have to understand that at a deep level, we have ensured the quality, robustness, and fairness of these products. Now, this brings us to the uses of these products. This is where each jurisdiction is going to have to make its rules. And this is, of course, where things get difficult. But there can be very, very helpful, useful risk assessments that will help determine when an AI system has very significant risk and where it falls on the continuum. And we will get better at this over time. Something that will really help in this area in terms of implementation. So the question was, is a risk-based approach too weak, not enough? It is enough. You have to start there. But then you also have to add the various other policy elements, which will be necessary. But the other thing is to think about implementation. At the end of the day, all of us are going to have to implement all of this. So here, there are two things that will be very critical. Number one, ISO standards, which already has been mentioned here and are very important. But also, I would mention what I would call regulator-approved codes of conduct. This is something that we see under GDPR Article 40. And jurisdictions that have GDPR-like legislation also have regulator-approved codes of conduct. These are very important. Currently, they're underutilized, but in AI, it would be very helpful because of we will have millions of AI systems and use cases, and these codes of conduct will help create an interface between the policy and the practice. And we really need that, and we need oversight. And I think self-regulation is a no-go here, for me at least. I think that it is proven to not succeed, but the regulator-approved codes of conduct is very important. As long as they are robust and not a rubber stamp, it needs to be meaningful. So those are my thoughts, and thank you again very much for this important conversation.
And I guess I am last but not least. Thank you again for the opportunity to share perspectives today. I think, in response to the question that was posed, I absolutely think that risk-based approaches are going to be effective here, and that there is an appropriate balance that can be struck. As was mentioned previously, I do think that there are particular controls and requirements, for example, that are proposed in the EU AI Act that will help to enable a certain level of accountability for AI systems. And certainly by my comments earlier, I did not mean to suggest that we don't think that all AI systems should be trustworthy, just that there are different sets of risks associated with those that might interact with humans and those that do not. We, of course, want every AI system to be held to a particular, standard and not be off doing something that they should not be doing. And so, the risk-based approach, though, I do think allows for an assessment of those systems that might need, a different set of standards or requirements or assessment versus those that maybe do not need that same level of assessment, or may not need to meet that level of stringent kind of review because of the ways in which they are operating or not with humans, or the ways in which they are potentially negatively impacting humans or not. And so that was kind of where I was going with the concept of human facing versus non-human facing. I think, additionally, it's just really about understanding what those different risk levels are. And again, I think the European Commission has taken an initial step, right, to determining kind of areas where systems may pose a higher risk. I do think that more can be done to kind of facilitate that conversation across borders, so that there are not kind of different ideas of what might be high risk in different areas, right? There might be a little bit of difference based on the criteria that's used, but I think to the extent that the criteria can be aligned, that will be incredibly helpful in ensuring that risk-based approaches are appropriately kind of interoperable across borders as this, continues to evolve and change. We really want those regulatory approaches to be principles-based and outcomes-based. So, right, allowing companies to focus on achieving specific outcomes related to accuracy or reliability or robustness, as opposed to like incorporating more specific technical prescriptive requirements that may not be appropriate for all instances. So, I think I will end there. Really appreciate again the opportunity to present today, and we'll look forward to continuing the discussion.
Thank you so much. Muitíssimo obrigada a todos os ilustres palestrantes desse painel.
Thank you so much to all speakers at this panel, Pam Dixon, Courtney Lang, e a todos, and to all. It was an extremely rich panel. So I thank you all. It definitely highly contributed to the situation that we are living in Brazil now, to think about regulations for artificial intelligence. So now I would like to give the floor to. Thank you so much. I would like to mention the other members who are present here, Professor Ana Frazão, and all others here present. And I would like to declare that this session is adjourned for lunchtime, and we'll come back at 2 p.m. with the next panel. So I would like again to thank you all for being so generous, for being here with your time. Thank you.